Hi everyone, welcome to our video series, How Not to Draft an International Arbitration Agreement. We're going to talk about some common drafting errors, and we're going to talk about some real-life examples where these drafting errors lead to some serious issues. And then we're going to talk about what are some different ways that you can sort of optimally draft arbitration clauses in cross-border contracts. What we're going to talk about today, especially, is the issue of dictating efficiency, specifically in the context of time limits in international arbitration. Sometimes parties want to ensure that there is a quick arbitration proceeding. They think it will be more efficient and less costly, which you can sort of see the logic of. But the question is, how do you get there? So there's actually a very interesting study by Chris Drauzal. He and another law professor look at the a number of international arbitration agreements, and specifically they look at how likely is it that certain terms will appear in those arbitration clauses in cross-border contracts. It turns out that about a quarter of cross-border contracts will have some sort of time limit on the conclusion of the arbitration proceedings. Now, what can happen if you have a time limit in your international arbitration clause? I think there's two major sorts of sets of issues that can occur that we'll talk about. The first one is if there is a lack of sort of specificity in the arbitration agreement as to what triggers and what concludes this time limit. So let's say that the time limit, let's say that the clause says that within 6 months, the arbitration proceedings will be concluded. The natural question is, within 6 months of what? For example, does that mean that the arbitration proceedings have to begin with do the arbitration proceedings begin with the initiation of arbitration by submitting a request for arbitration? Does it mean notification to the other side? Does it mean the composition of the arbitral tribunal? Does it mean the case management conference, etc.? And then another issue is what causes the sort of end of the time limit? So is it the final award? Is it the conclusion of the hearings? Is it the closing of briefing, etc.? So one issue is specificity. And then another issue that can arise is the length of the time limit. Why is this a huge problem? Why can this cause problems? Well, the time limit can either be too short or too long. So if the time limit is too long, then your time limit has had no effect really on the arbitration and how efficient it is or anything like that. If the arbitration can be resolved within a year and you put a 3-year time limit in an international arbitration agreement, then it has done nothing. It has served no purpose. Let's say that the opposite problem happens and the arbitration agreement has a time limit that is too short, is unreasonably short. There are a number of problems that can result from that. And we'll talk about, I think, 3 sort of categories of them. The first is what happens if the award is not issued within that time limit. Then the issue is what happens if the award is issued within the time limit. And I should say not just the award being issued or the arbitration being concluded in whatever way is specified in the contract. Let's say that the arbitration does conclude within the time limit, but the parties have endured maybe a lot more cuts to the process than they were expecting. And the arbitrator has had to maybe possibly remove some of their due process or deny a little bit of due process by having maybe unreasonably short periods for drafting of the briefs or maybe unreasonably short time to do document disclosure, whatever it may be. A party might claim that there is a lack of a due process and it can throw the award into dispute. And then the third problem is what happens, what are the incentives that the parties have as they are approaching that time limit. So let's start at the beginning again. Problem 1, if the award is not issued within the contractual time limit, then once the award is issued, a party might claim that the award is not valid and should not be enforced. That's under Article 5.1d of the New York Convention. And the New York Convention, that treaty, says that if the arbitration was not conducted or I'm sorry, if the arbitral procedure was not in accordance with the agreement of the parties, then recognition of the arbitral award can be denied. Now, in the US, most often, what the courts will say is that the arbitration not being finished within the time limit will not affect the validity of the award. So what the courts will usually point to is that either the tribunal essentially gave itself more time using its powers, or there simply was a lack of material harm that resulted from the arbitration award not being issued within time. But in around the world, we're talking about many possible different enforcement jurisdictions. Not all of them do take that view, and there is no world sort of consensus on it. So you create a lot of uncertainty with respect to the issue of what happens when the award is not issued in time. Just for example, some French and Swiss decisions have refused recognition and enforcement of awards on the basis of not being issued within a time limit. Some cases from Germany have examined this issue as a question of Article 5.1c of the New York Convention. So they've examined it as a question of excess of powers. But that's not common. I think most courts around the world really look at this through Article 5.1d, which is much more obviously applicable. So again, we're talking about the award not being issued quickly enough. If the award is not issued quickly enough, another problem that might arise is before the award is issued, but after that time limit has passed, a party might decide to open a new proceeding. And we're going to talk about this situation in the Sullivan versus Feldman case, which is our real life example that we talked about. And it does leave some ambiguity about what is the jurisdiction of that arbitrator once the time limit has passed. So the second set of problems I think we've already covered, which is due process concerns as a result of the measures that the arbitrator or arbitral tribunal took to try to get within that 6-month time period. And then problem 3 is a strategic issue, and it's a question of bad incentives. Sometimes, if the time limit again is unreasonably short, then the parties might have some bad incentives, and as they are approaching that time limit. And this could actually happen even if the time limit is not unreasonably short. If one party is losing, or it knows that it has the weaker arguments, and it's coming up, and the parties are coming up on their time limit, one party, that losing party, might want to delay the proceedings. They will certainly have the incentive to do so because it knows that it can call into question the validity of the award, and it can tank the whole proceedings. So I think those are 3 major issues that are a result of an unreasonably short time period in an arbitral agreement. I think what I'm going to talk about next is the preferred method for sort of dictating that efficiency that you're looking for, and not using time limits, but rather using expedited procedures. But if you still want to use those time limits, there are some tips that will make your life a little bit easier. First of all, the parties will have to do careful research on the law of the possible enforcement jurisdictions and the seat of arbitration with respect to the validity of the time limits, and more importantly, what happens if the time limit is not met. It could be different, for example, if there is a French and a Brazilian company in a contract, and one of the companies has assets in the United States. Ideally, the parties will have an understanding of the laws in the possible enforcement jurisdictions in France, in Brazil, and the United States with respect to what happens if the time limit is not met. Another thing that the parties can do that's extremely helpful is to have a sort of release valve in the agreement. So, for example, the arbitration agreement can say that if the time limit, if the arbitrator or arbitral tribunal finds that there are compelling circumstances, then it will conduct the proceedings, or it will continue within X number of days, and it will issue an award or conclude the proceedings within X number of days or X number of months. Again, this is a way to sort of protect the validity of the award. Probably the most critical issue is making sure that the time limit is reasonable in terms of the complexity of the dispute and the amount of money in dispute. So, for example, an EPC contract or some sort of very technical contract where a long period of performance is envisioned. There are a lot of technical issues, and there's a great amount of money in dispute. A 6-month time limit will simply not work. It's also very important to be specific about what starts and stops the clock. We've already talked about that. And then one thing that the parties can do that is super important is to make sure that they specify that failure to meet that time limit does not affect the validity of the award, right? Because even if, no matter how much you want that award to be issued within that certain time period, you might run into a situation where it isn't issued, and then it's not clear whether the parties can continue in a new proceeding or if there is some other sort of solution. So now we're going to talk about the problems that can arise that we've already talked about. We're going to talk about a real life situation that demonstrates these. So Sullivan versus Feldman is not an international case, but it is about an arbitration, and it displays all the problems that we talked about. This is an agreement involving insurers, doctors, and a law firm, and it's about a sort of complicated series of insurance and tax management sort of issues and services that were provided to healthcare providers. So you can already see that there's a lot of complexity to these issues, so maybe a short time period isn't appropriate. And you can also see in the amount in controversy here. So this dispute, the contract was involving tens of millions of dollars of services, and that was eventually the amount of money that you see reflected in the awards. So it is sort of a surprise to see that there's an arbitration agreement that gives a 4-month time period. The arbitration agreement says that there will be final resolution of a dispute in an arbitration proceeding to be concluded within 4 months. So what's that problem we've seen? First of all, lack of specificity. What does concluded mean? Does it mean the issuance of the award, etc.? And then 4 months. I think we know after this video that 4 months is not a reasonable time period given the complexity of this dispute. So we know that there are these issues. What did the parties actually do? They actually foresaw some of the problems, or at least the party that drafted this arbitration agreement, and it said, maybe the award is not issued within a certain time. We'll give the court some guidance on what to do. And what it said is, if the first arbitrator or arbitral organization, which receives a written demand for arbitration of the dispute from either of us, the parties, does not complete the arbitration to finality within 4 months of receiving the written demand, any party then may file another written demand for arbitration of the dispute with another recognized neutral arbitrator or arbitral association, with the prior arbitrator or arbitral association then being immediately divested of jurisdiction. So what that means is a party initiates arbitration. Arbitration might continue for 4 months. If the arbitration award is not issued, another party or that party may go and start a new arbitration proceeding in a totally different institution. And that other arbitration, those 4 months are completely lost. So the parties may have briefed, they may have had document disclosure, they may have even gone to a hearing, and it has all been a waste. Another issue that was in this case is that there are a lot of different parties. Again, it's a multi-party arbitration agreement, and it's critical to draft them in a certain way, especially when it comes to these time limits, because in this case, we had 9 different arbitrations for 9 different arbitration from 9 different arbitrators. So this is the kind of thing that we are trying to avoid when we enter into arbitration, because in court, there can be all these sorts of issues of consolidation, etc. Hopefully, we draft the arbitration agreement in a way that avoids this, and usually you do. I think the sort of very peculiar way that this arbitration agreement was drafted, you had 9 different arbitration proceedings. Some of them were issued within the time limit, some of them weren't. And what the arbitrators actually said is they got together, sort of consolidated, and tried to put their heads together in this solution because these arbitration proceedings were all over the country. This is in the United States. And the arbitrator said this 4-month period is just invalid, and it refused to enforce it. And we, the arbitrators, are going to continue and issue our awards, sort of just ignoring that. And the arbitration proceedings concluded. Multiple arbitration awards were granted, were sort of recognized, and the arbitrators had a very interesting take on the situation. They said they actually issued a joint order that said there is no question that the cause of the multiple arbitrations and the chaos in this case is the arbitration provision. So what is it that you do want to do? If parties are looking for that efficiency and expedience, and they want to they want efficiency. Well, arbitral institutions have expedited procedures. The International Chamber of Commerce, the Singapore International Arbitration Center, International Center for Dispute Resolution, they all have expedited procedures, and they have various sort of thresholds. What dollar amount will trigger those expedited procedures? And the expedited procedures give the arbitrator either discretion or a default rule that will allow the arbitrator or arbitrators to conduct the proceedings more quickly. There's a 6-month time limit usually, and within that time limit, the arbitration will be it will be expedited. So, for example, there might not be a hearing unless the parties agree to it. The arbitrator can rule on the dispute on the basis of the papers or the submissions and the fact witnesses and expert witness statements that have been submitted. And the good thing is the parties have agreed to this institution. They've implicitly agreed to the arbitration rules of that institution. And so there isn't going to be a question of due process concerns because of the sort of shortcut provisions, or the shortcut methods that the arbitrator used to get within that time limit. Another thing is you can achieve this efficiency through these expedited procedures of an arbitral institution without calling into question the validity of the award, because the arbitrators have, or I'm sorry, the arbitral institutions have very creative ways of ensuring efficiency. So, for example, the ICC will actually cut arbitrators' fees if the arbitral award is not issued within a specific period of time. And you know for a fact that that will cause the arbitrators to move quickly, but it doesn't throw the ultimate award, into doubt. So I think generally our conclusion is that when it comes to time limits in international arbitration, it's very, very tricky to draft them in a way that doesn't cause problems, either inefficiency, bad incentives, or even possibly parallel proceedings, wasteful proceedings, or an award being called into question. We really recommend expedited procedures. I think most international arbitration experts recommend expedited procedures over contractual time limit. And if you're interested in this topic, or you're interested in international dispute resolution, I hope you'll stick around for future videos, and I hope you'll subscribe to this channel. Thanks.